Hey gang, it's me, Dr. Steve, coming to you from the beautiful Hudson Valley in upstate New York on a very much needed vacation. As you know, we've been working really hard with international classical school movements throughout the world that's reawakening conservative Christian civilization. And so now, it's time for me to get a little rest and relaxation here. But I just had to comment on the 1-2 gut punch that we all just got from the supposedly conservative justices Roberts and Barrett on the Supreme Court. I'm sure most of you have heard by now, as of this morning, the court has indeed struck down President Trump's executive order on birthright citizenship, and that abysmal decision followed yesterday's blow to election integrity, where the same two justices joined the three liberal idiots to allow mail-in ballots to be counted days after Election Day. So let's take each in turn. So you might recall President Trump on January 20th of 2025, his very first day back in office, he directed federal agencies through an EO not to recognize the citizenship of babies born in the United States if either parent was illegal. The administration's argument was very straightforward. The 14th Amendment says citizenship belongs to persons born or naturalized in the United States and subject to the jurisdiction thereof. So it's those last 6 words. I mean, they're not decoration, right? All children born in the United States to parents who are not under the jurisdiction of this nation, like an ambassador or a diplomat, or like children of tribal Indians. Their children are born in the United States are not recognized as United States citizens, and neither should illegal migrants who are by definition still under the jurisdiction of their own countries of origin. But somehow, some way, the two supposed conservative justices, both nominated by Republican presidents, Roberts and Barrett, have embraced the insanity of the left that's just infested modern jurisprudence, and they've ruled that children born to illegals inside the country are indeed automatically U.S. citizens. Even my namesake, Jonathan Turley, the law professor, who's not a conservative, he says that this constitutional interpretation is utterly insane. Well, his exact words are, it's perfectly insane. And he thinks this is going to force us to try to ultimately pass a constitutional amendment that permanently defines the jurisdiction clause as excluding children of illegal migrants. Now, the good news is that the border is shut because of the very policies that were instituted on that very day, January 20th, 2025, the same day President Trump issued his executive order. Since that day, there has been 0 illegal border crossings. 0. That's not an exaggeration. And keep in mind, the anchor baby strategy that's tied to this birthright citizenship is officially dead. So an illegal alien parent is absolutely still subject to deportation, even if their child's a U.S. citizen. Courts have upheld that for 50 years. Having a U.S. citizen child is not the equivalent of getting a visa. A U.S. citizen child cannot petition for a parent's green card until the child turns 21. So even setting deportation aside, the anchor doesn't legally attach. If the parent is deported before the child can petition for them, a child turning 21, if the parent's deported, they have 2 choices. They could leave the child here with U.S.-based relatives, or they can take the child with them. Technically speaking, the child is not being deported. The parent simply chooses to bring them in their deportation. And under Trump's current enforcement posture, prosecutorial discretion, as it's been called, that's where ICE would previously deprioritize parents of citizen children like they did under the Biden administration, that's dead. That's gone. And it will be gone for the next few years. But all of that said, this decision this morning, as well as the blow to election integrity yesterday, are 2 very painful reminders that Roberts and Barrett are not conservatives. They are not constitutional originalists like Thomas and Alito and Gorsuch and Kavanaugh. Kavanaugh's gotten much more originalist, actually, as time's gone on. Roberts and Barrett are not originalists. They are institutionalists. That's a very important distinction to get. They are not originalists. They are institutionalists. They care more about the court's reputation than they do about fidelity to the Constitution. They care more about avoiding political controversy than deciding in favor of our constitutional republic. So when you've got the other justices in default cases running home to their judicial philosophy, either on the left or the right, Roberts and Barrett run home to stability. And that's not textualism. That's judicial timidity dressed up in constitutional robes. And that's exactly what we're going to have to fight against when a Republican president is set to nominate the next Supreme Court justice. The smell test is no longer constitutional originalism. The smell test is whether they're institutionalists, whether they're going to allow their devotion to the court's reputation overrule their supposed commitment to constitutional originalism. And we frankly saw the same thing yesterday with their blow to election integrity. And all of that forces us to ask, what do we do? What decisive actions can we take to finally resolve this judicial insanity? And that is exactly what we're about to find out.
I know you keep telling yourself at some point in the future you're going to buy and store away a few dozen gallons of water just in case an emergency hits your family and the water shuts off. We've all experienced it. The storm hits, the faucet stops working, and we're left wondering how long it's going to be before we have drinking water again. Every time it happens, we kick ourselves for not being more prepared. Well, here's an easy step that you can take that costs less than a dinner out. It's called the Pure Water Straw, and it can clean an entire year of water for you. It's absolutely amazing. It's the perfect emergency tool for making sure your family always has clean water through a disaster. So I got a little bit of some dirty water here, as it were, and what you do is you just take it out and you take the top off, and then what you can do is you can drink from any water source, no matter how dirty. Check this out. I'm kidding. I kid you not. It tastes just like water. This is coffee, obviously. I don't taste the coffee. It's just water. I mean, this is amazing. The Pure Water Straw allows you to drink from literally any water source, from the pond, from the mud puddle, the bucket that caught the rainwater, even, I kid you not, even the toilet. The Pure Water Straw instantly cleans out bacteria, pathogens, and debris and purifies the water. So you can drink clean water from any source without worrying about, puking your guts out. We have these in our home. We got them in our cars. We've got them in our go bags. Or emergency responders actually recommend having one of these on hand for every member of your household. They store well in their sealed bag. It's a tool your family would be able to count on for years to come. Now, if a takeout meal is more important than a year of clean water for your family, well, then obviously the Pure Water Straw isn't for you. But if you know how important clean water is and understand how quickly a disaster can change everything, then getting a few of these Pure Water Straws is a no-brainer. It's the most logical next step, both for your peace of mind, but also from an investment price standpoint, because normally these are $45 each, but today the makers, Sierra Madre, need to make some space in their Wisconsin warehouse, and so they're marking these guys down over 60% with free shipping to boot. Click the link in the description below and grab yours today so your family's ready for the next crisis or disaster. You won't regret it. Click on that link below right now.
So yesterday, in a 5-4 decision, Justice Barrett, joined by Roberts and the 3 liberal justices, upheld a Mississippi law allowing mail-in ballots postmarked by Election Day to be received and counted up to 5 days later. 14 states, all blue states, have similar laws. And Barrett wrote that federal law specifies that a vote must be cast, but not when a ballot must be received. So therefore, states can set up their own receipt deadlines. Now, Justice Alito, who's joined by Thomas, Gorsuch, and Kavanaugh, they wrote a scorching dissent, pointing out that Election Day is a specified date, not a span of multiple days. The Election Day statutes require that federal elections occur on that date. But if the collection of ballots continue for days on end afterward, like they did in Mississippi here, the election's not held until the end of that period. So there is not an election day. There are de facto election days, which contradicts the statute designating a single day for the election. That's not spin. That's the plain reading of the statute. Federal law designates the first Tuesday of November as election day, not election week, not election month, right? Congress sets the date, one day, and now this 5-4 decision allows states to shred that deadline by simply calling the extended counting period something other than the election. And if it's California, you could literally be counting for months on end after the federally mandated date. Now, Roberts and Barrett are effectively saying that the federal government can set the date, but there's nothing that constitutionally mandates how state legislatures have to honor it. And the irony here is beyond oblivious, I guess, to them. When it came to birthright citizenship, a question of executive power over immigration that the federal government gives to the president, they were willing to override the president by refusing to read the text as originally intended by the framers. But when it comes to election integrity and a clear federal statute, well, suddenly, it's all about supposedly what the Constitution originally mandated. It was never the actual outwork. So you can't have it both ways. Either the court reads texts honestly and applies them, or it defers. Robert and Barrett chose deferral when it inconveniences conservatives, and activism when it inconveniences the left. That's not judicial philosophy. That's a pattern. They're institutionalists, and they see as their job the responsibility of supposedly balancing the court so that the right doesn't get too much of it wants and the left doesn't get too much of what it wants. So they're actively obstructing constitutional originalism, at least when it comes to decisions like this. So bottom line, moving forward, we now know exactly what we need to prevent in the next Supreme Court appointments. We're slowly getting rid of the Senate rhinos, and the national trajectory is clearly moving in the conservative direction. So enough of these institutionalists across the board. We need faithful, unapologetic originalists. So that's number one. Secondly, the more red the country gets, the more red states accumulate, the easier it's going to be for us to pass constitutional amendments. And that's, in the end, really what we're going to have to do to push back against the court. The left can talk about, stacking them, packing the court all they want. They're losing political geography. To ratify a constitutional amendment, 38 out of the 50 states have to approve it. That's 3/4. And you actually only need 34 states to hold an Article 5 constitutional convention that bypasses Congress in the proposal of constitutional amendments. And the simple fact is Republicans are quickly controlling more and more and more state legislatures. We're getting very close. Right now, we're at 28 state legislatures that we're controlling. And it's only going to continue to grow with the voter registration crisis that the Democrats are facing. So we're just 4 or 5 states away from being able to actually call an Article 5 constitutional convention and rectify this nonsense. So I think in the end, what all of this means is that today's SCOTUS ruling on birthright citizenship is really actually a clarion call for the Article 5 movement. If the court won't read the Constitution honestly, then we, the people, can rewrite the relevant clauses. And Republicans are closer to having the state-level power to do that than at any other point in modern history. And then in the meantime, we got to push the Senate to pass the SAVE Act, which would require proof of citizenship. It would restrict mail-in ballots. It would do the job the court's telling the legislature to do. The court just told us they're not going to, rewrite the statute. You have to do that, and so we should say, fine, we will rewrite it in such a way that guarantees election integrity for this way forward. But bottom line, the court failed the country. Bottom line. They put their own institutionalism in front of what's best for the nation and what's most faithful to the Constitution. So it's our job to keep going, to keep fighting, and yes, ultimately, we most certainly and will inevitably win. So what do you guys think? I want to hear it in the comments below. I know we tend to try to be as optimistic as possible, but hey, we got to call the shots, and we got a couple of gut punches. So let me know what you think in the comments below. And as always, make sure to smack that bell and subscribe button for breaking news and analysis you ain't going to get anywhere else. Love you guys. Going back to my vacation. God bless.
Hey, listen, you see what's happening to your faith, your family, your freedom. You shouldn't have to face that alone. Inside the Courageous Patriot Club, you're shoulder to shoulder with people who actually see the world the way you do and refuse to back down. Click the link below, jump into the club, and come stand with us this week.